Question: can the police lawfully stop my car during a drink drive campaign? In short, the answer is yes, even if you're a teetotaler. Let me make 10 points to outline lawful and unlawful police actions during a drink drive police campaign and what you are and are not legally required to do. Point 1. As part of a drink drive campaign, the police have wide police powers to stop vehicles to check the driver is lawfully on the road, including to check they're not over the drink drive limit and thus not a danger to others. Point 2. Section 163 of the Road Traffic Act is the power the police rely on to stop vehicles in a drink drive campaign, which states a person driving a mechanically propelled vehicle on a road must stop the vehicle on being required to do so by a constable in uniform or a traffic officer. Point 3. Under Section 163, the officer does not need a specific reason for stopping the vehicle, e.g. observing the vehicle being driven erratically, or intel from a third party alleging you're over the drink drive limit. This is because Section 163 is a suspicionless police stop power, so theoretically, any driver can be stopped on a road. Point 4. To use Section 163 power lawfully during a drink drive campaign, an officer must be in uniform and be lawfully acting in the course of their police duty and make the stop for a proper legal reason, e.g. as part of a drink drive campaign. Case law has confirmed the use of police vehicle stop powers as part of a drink drive campaign is lawful as long as no police malpractice is involved. Point 5. What would be an unlawful use of Section 163 police vehicle stop during a drink drive campaign would be if the officer discriminates in the drivers they stop, e.g. based on race, sex and religion. Point 6. During the drink drive campaign, the officer can lawfully ask to see your license, insurance, MOT, and the officer can lawfully ask for you to state your date of birth and to give the name, address of the owner of the vehicle as per 163, 164 and 165 of the Road Traffic Act. And you as the driver are legally required to provide such details. Point 7. During the drink drive campaign, Section 163 vehicle stop, an officer can also legally ask you other questions, e.g. about where you have driven from and where you're driving to, and may ask you to step out of the vehicle. Unless there is another legal police power at play, you do not need to legally answer these police questions, and neither are you legally required to step out of your vehicle. Point 8. Further, following the vehicle stop, if the officer reasonably suspects you are or have been driving over the alcohol limit based on an objective assessment, e.g. the officer observes that your eyes are glazed, you are slurring your speech and the officer smells alcohol, the officer can lawfully ask you to step out of the vehicle and detain you to carry out one of the 3 types of preliminary roadside tests: a breath test, an impairment test and a drugs test. And you are legally required to cooperate with this process, including the preliminary roadside tests. Point 9. Offences during a drink drive campaign include: if you fail to stop your vehicle during a lawful vehicle police stop, you commit an offence. If you fail to provide driver details and documents without a defence, that is within 7 days of being asked to produce them at the police station, you commit an offence. If you fail to cooperate with a lawful preliminary roadside test, you commit an offence. And if you test for alcohol over the limit at the roadside, you can be arrested and taken to the police station for an evidential test to be carried out there. Point 10. So, drink drive campaigns by the police involving random vehicle stops are generally lawful. But if you have concerns about your vehicle being stopped by an officer, please seek legal advice. Feel free to comment, follow, like and share.